Good day, everyone. Welcome to Helps YouTube Live today, Monday, January 12th. My name is Eric Olsen, lead attorney for Helps. Helps is a national law firm that represents seniors and disabled persons who owe debt they can't afford to pay. And we represent people in order to stop debt collector harassment. And we do that under a law called the Fair Debt Collection Practices Act that was passed in 1978 that provides one of the things that provides if you're represented by an attorney, debt collectors can no longer call or send you demand letters anymore. They have to leave you alone. Okay? So when people find out about Helps, they call us. We ask them some questions when they may call us 3 or 4 or 5, 6, 7 times, whatever. When they enroll, we can enroll them over the phone immediately. Then we click a button and you get an email. We keep you on the line. The email says, "Welcome to Helps." Then you can text, fax, email, or mail us the creditors you owe money to. All we need is the name and address. We don't need the balance that you owe. And then within 24 to 48 hours, or sooner than that, we're going to send a cease and desist letter out to that debt collector. But when we hang up the phone with you, you're our client. Payment won't begin till 30 to 60 days in the future. Maybe 1 out of 6 or 7 of our clients get our help for free. We don't turn anyone away that needs our help. And we do this YouTube Live. Our second mission is to educate seniors on how they can maintain their financial independence. And that's why we have these YouTube Live sessions where you can ask me questions, but I also have things that I've written out here that people that called into Helps or people that we've enrolled or even existing clients that I think would be helpful for you guys to know. Okay? So that's what we do, and I'm happy to answer your questions. So Tweety Bird says, I sent a letter to the counselor for his review and feedback. Another bankruptcy attorney states that commingling funds in your Social Security deposit account could be garnished, like you must keep all funds separate. Well, that may have been true before 2012, but the law changed in 2012. And if you've listened to me before, I think I've said maybe 1 out of 1,000 attorneys don't know that rule. Even though it's been in effect for the last 15 years or whatever it is, you know, they don't know what the rule is. But there's a department in the bank that understands the rule. They know what the rule is. Your bank manager doesn't know what the rule is. I've yet talked to one that does. So it's kind of like 10 Commandments. It's one of the it's out there. Okay, it's the law. I don't need to get an argument with any. I mean, or you could Google and search it, and you're going to find the links to the stuff. We have. I was going to, if I had enough time, I was going to show you some emails that we send to people or something that explain that. But it's so basic now. Okay. Let me tell you why that law was put into effect. Okay, before 2012, if you were a senior getting Social Security and someone sued you and got a judgment, okay, and they filed a writ of garnishment against your bank account, okay, the bank would honor the garnishment. What you had to do was file a challenge to garnishment or claim of exemption to get the court to order the money be released. And so what I know what's happening is that seniors were calling their congressman and complaining. And a lot of seniors, probably a majority of them, didn't know they could file paperwork with the court to get that money released. And a lot of them weren't in a position to do that. Maybe they didn't have the wherewithal to do that. And so they were losing their Social Security and it was going to pay creditors. Finally, someone had a brain in the government and they put in this rule in effect. Okay, it was actually a rule. And they told the banks that they're to examine if they get a writ of garnishment, they're to examine where the money came from. If it came from a federal source like Social Security or retirement for VA retirement or post office retirement, which is a federal retirement, or a federal retirement, any federal fund, that amount received within the last 60 days, which is usually 2 months, is protected automatically without regard to the source of funds in the account. So when they went to pass this rule, the bank said, well, are we going to have to determine if other money's in there, or are we going to have to determine just protect the amount that came from the federal source? That's going to be really difficult for us to do. And so the rule said, no, you don't have to do that. All you need to do is find out what the federal amount is times 2. That amount is protected regardless if there's monies in there commingled from another source. But there's a lot of attorneys that still don't know this rule. Okay, and that's who you talk to, Tweety Bird, someone who didn't know the rule. You can call us, we can see email. I mean, it's so basic that now it took a while to get all the banks and credit unions on board. The credit unions were slow to the table. We had to educate a lot of them about the law, but we don't have the problem anymore. They pretty much know. They have departments within the credit union banks that deal with garnishments. They know. Now, it is true that your bank account could be garnished for child support. Taxes could offset 15% of your Social Security. We don't see them garnishing pensions. But if you're lower or modest income senior, you probably qualify for what's called currently not collectible status with IRS. Now, a state tax collector can't touch your account. It's protected, your bank account, to which Social Security goes. Yeah, you're right. He's mostly wrong. He's right. They could come after for past child. I don't run into a problem with our seniors owing past child support. And if you did and you had a problem like that, call and talk to me. There are a couple little things that could be done, but I don't want to talk about them here. Okay, so that deals with that. So this person writes in from Maryland, and they say, I need help before they put a judgment against me in court. I tried to work out a settlement. The credit card company would not work with a reasonable amount a month. Please help. 4 exclamation points. Well, we're going to call this guy if we haven't already. If he gets Social Security or pension or retirement income and he owes the money, he doesn't have to worry. There's nothing you need to, they can get a judgment, but you're what's called judgment proof, which means your Social Security and your retirement income, your pension, it's protected. Okay? And as long as you keep the balance in your bank account less than twice the amount of your federal benefit, like I just explained, if they were to ever garnish your bank account, which is highly unlikely, but if they tried, your bank will protect that automatically. Now, if you happen to have more than that in there, it doesn't mean it's not protected. It's just not protected automatically. You could file challenge to garnishment or claim exemption, and the judge would order the money be released. Occasionally, that happens with one of HELP's clients, and we'll help them do that. We'll tell them how to do that and give them some information. But if you just keep the balance less than twice the amount, you'll never have that problem. So you don't need to settle the debt. Which reminds me of a client I talked to this morning. I put this down from Massachusetts and been a client of HELP's for several years. And I wrote down, spoke to an existing client this morning, wanted to know about paying for new debt she had, new credit card debt. And she wanted to know where she could get a loan to pay it. I said, what's your income? And she's like $1,400 or $1,500 Social Security. And I said, you don't need to pay that debt. Oh, what do you mean, Eric? I enrolled in HELP's a couple of years ago, and this is new debt. Well, what I suspect was it was credit card debt that she had before that she didn't give to us, and now she's racked it up and she finds she can't pay it. I told her you don't need to pay it. Just turn it into HELP's. So when you enroll in HELP's, you give us the debt creditors you owe money to, and for whatever reason you forget one or you incurred a new debt that you couldn't pay in the future, you get that to us in the future. We'll send them a cease and desist letter. You don't need to pay it. So HELP's our help is not a one-time thing. It's literally ongoing. Okay. So you don't need to worry. If you incur new debt, you don't need to worry. So mom says, your website says you can't help me in North Carolina. I'm panicking. What can I do? Will I be in danger if I just stop paying I can't afford bankruptcy? Well, okay. What we can't do in North Carolina is we can't send cease and desist letters from helps. But we'll be glad to talk to you and give you links. You're going to be fine. And you're not going to get charged anything. You call and talk to us. And ask to speak with one of the attorneys. We'll give you some links. Okay, you're going to be fine. See, the laws we talk about here at Helps are effect in all 50 states, not just one or two states, all 50 states. And they're effective in North Carolina as well. Blind says, several years ago, I was going to file bankruptcy and the attorney told me to look into Helps. I was very impressed with the honesty and I've sent people to him because of it. He still made money. You bet. I could tell you about that. When a debt collector sues, must they have a chain of custody of all of the previous owners of the debt? If they don't have, could a lawsuit be thrown out? Okay, first off, Helps, we don't deal with how to defend against a lawsuit. Okay? It's not what we do. Do they have to have a chain of custody? They might, and it's pretty easy to do that. Most of our clients aren't interested in trying to defend a lawsuit. They don't know how to do it. They're scared of the court system. If you can get on the internet if you want to try to do that, in some ways it's a game, and play that game you can. Okay? Okay. Now, I'm not saying you shouldn't do it. I'm just saying that, we don't help people do that. It's not what we do. We don't see our clients are judgment proof. Their income is Social Security, their pension is protected, their assets are protected. They don't need to worry. If one of our clients gets sued, we ask you that you send us a copy of the lawsuit. We need the first 3 or 4 pages, or 2 or 3 pages. We need the name and address of the attorney, the case number. And we're going to send a letter to the attorney, let him know that your income is protected, you're not going to pay the debt. We're going to call you on the phone, tell you why you don't need to go to court and why you don't need to worry. We're going to send you an email with information about that, why you're going to be okay. Okay? That's what we do. Yep. Your Social Security. Yeah. Your federal benefit, Social Security, federal pension, VA benefit, whatever it is, it does have a code on the deposit. And they can tell that. But remember what I said? Maybe 1 out of 1,000 attorneys understand that rule. There might be a few more than that, but I suspect not many do, even though that rule's been in effect since 2012. Okay. Person contacts us from Ohio. Well, actually, this is someone else. They're returning an RV. They get Social Security and a little annuity. They can't keep up on the RV with other credit card debt. They're current so far, and they called in with their daughter. You can return the RV, let it go back. You can stop paying the other debt. Eventually, the RV is going to get sold. You're going to get a demand from the letter called a notice of deficiency, stating how much you owe, assuming they don't sell enough to pay off the loan, which is probably going to be the case. And then if you're enrolled in Helps, you get us that notice of deficiency. We're going to send a letter to the lender or the party to whom you owe the money and let them know that you can't pay it. And we're going to advise you why your income's protected and why you don't need to worry about it, as you don't need to worry about your other credit card debt. Person from Ohio writes in, they say, I'm in the process of foreclosure on my home due to mortgage debt. I have lived here in my home over 40 years. I do not want to lose my home. If anyone can contact me, I would appreciate it. So, um, when you enroll in HELPS, you can stop paying all this other debt and you'll have money with which to pay the mortgage. But let's say the mortgage is far enough behind, or they're not going to work with you. It's too much. And they're proceeding on with the foreclosure. What's your solution? You got a couple of them. One, if you got enough equity in the home, you could sell the home. Theoretically, if you got a lot of equity, you could get a reverse mortgage that would pay off the existing mortgage, stop the foreclosure, and then you own the home without having to make a payment on it anymore. And there is a bankruptcy option called a Chapter 13. That bankruptcy would stop a foreclosure. Then you could resume making your regular mortgage payment, and then the amount that you owe for the missed mortgage payments, you would make payments over a period of 3 to 5 years to catch up on those. And that may be a solution. Assuming other things come into play. But you can call and talk to us. We don't file Chapter 13s for people or bankruptcy, although I filed 30 or 40,000 bankruptcies before I started HELPS, so I know all about it. But we'll tell you what you can do. Things will work out, okay? Person contacts us from California, and they say, I'm getting behind on my credit cards by almost 3 months now due to financial hardship situation. I'm afraid that the situation might jeopardize my low income housing here in Los Angeles. I'm getting desperate with no way to go. Can you please give me some advice? Thank you very much for your time. Well, I'm assuming this person gets retirement income, Social Security, or pension. So all our income is protected, or his income, whatever. He doesn't need to pay the debt. Now, you want to stay current on your mortgage or your rent payment, and the fact that you owe debt or get sued for a debt isn't going to affect your senior housing there in California. You can keep making that payment. So when a person says, I'm desperate with no way to go, no, you don't need to feel desperate. You're going to be okay. You can stop paying the credit card debt. You stop paying it 3 months, you can stop paying it, and you can use that money to maintain your mortgage, your rent payment on your low income housing, and you're going to be okay. Now, if you don't want to be hounded by the creditors, you're going to call HELPS. We're going to enroll you, and then you're going to send letters to these people you owe money to, and we're going to tell you that you can call us whenever you want if you're worried or scared, and we'll explain why you're going to be okay and why you don't need to be worried and scared. That's the beauty of HELPS, I think, is that we represent seeing our clients ongoing, not just one time. So Gina asks, what age is legally when someone is called a senior? Well, okay, the laws that we talk about today that protect your income apply regardless of age. It's your source of income. So if your income is Social Security, you could be in your 20s or 30s, be disabled and get Social Security. You could enroll in HELPS. You don't have to pay the debt. Your income's protected. So we have a lot of clients in their 40s, 50s, and 60s. So there's no magic age. Now, we call HELP stands for Help Eliminate Legal Problems for Seniors. The part we leave out is and disabled. So, we help no matter what. Hello, this is Anna from California. I send HELPS all my credit card info and address. Do they send my creditors a letter? Yeah, that's what we do. We send them what's called a cease and desist letter. We let them know that you can't afford to pay the debt anymore. So maybe if 5 people call us, maybe 1 is being sued, 3 or 4 are behind and getting harassed by creditors, and 1 out of 5 is completely current. It doesn't matter who you are. Now, the Fair Debt Collection Practices Act, that's the law HELPS operates under, that applies to debt collectors, not original creditors. Although 7 states it does apply to original creditors. But it's our experience that helps. If we send a cease and desist letter, we're going to send it to an original creditor like your credit card company, and they're going to stop calling you. And they may still send you a bill, but they're not going to stop. They're going to stop calling you. Okay? So you don't need to worry, Anna. You're going to be fine. So I had written this down because I talked to a couple people today that had been sued, and they called me and they were worried. And so I'm supposed to talk about what happens when a HELPS client is sued. A lady in Wisconsin and a guy in Texas, both on Social Security. Well, what normally happens is, here at HELPS, is a client's going to call us, or maybe it's a prospective client, and someone served them some legal papers, and they're scared. And we're going to explain to them, go over their income. If Social Security, it's a pension, we're going to say, that income's protected. Do you owe the money? And they're going to say, yes, we owe it. I said, well, you don't really need to do anything. Eventually, they'll get a judgment. How many bank accounts? You just have 1 bank account? And is that the account to which your Social Security goes? And they'll say, yes. And then we'll explain, explain how that twice the amount that they get, whatever they got within the last 60 days, which is normally twice the amount of their federal benefit, is automatically protected from garnishment, regardless of what other funds are in there or where they came from. And then we'll explain how we're going to send a letter to the attorney that sued you. And all we need is the first 3 or 4 pages. And that letter explains to the attorney that your income is protected, that you can't afford to pay the debt, you're not going to pay it. We understand they're going to get a judgment. Remind them of the protected nature of your bank account, although we really don't need to do that. And then we call you on the phone, explaining why you're not going to need to go to court. We send you emails with links to emails from HELPS with videos and articles that explains how your income is protected. So that's what we do. If just because you enroll in HELPS doesn't guarantee you're not going to be sued. Probably more unlikely that you would be sued, but it doesn't matter if you're sued. Sometimes they'll tell people you could have 100 people sue you for $100 million. Your Social Security is still going to be protected. You don't need to worry. What kind of TV shows do I like to watch? Well, I'm kind of a news addict. And if I liked a movie, I like a good romance. But I'm a news addict. When does the debt go completely away after you stop paying it? We don't need to worry about it, but I'll explain. Okay, so every state has what's called a statute of limitations. And what that means is it gives them a certain time period when a creditor can legally sue you to have a court say that you owe the debt. Now, in some states it might be as little as 3 years. Commonly, it'd be 5 or 6 years. Could be longer, but it's usually 5 or 6 years. And usually that's from the time when either you incurred the debt or when you last made a payment on the debt. So, for example, if you incurred a debt, if statute of limitation where you live is 6 years and you incurred a debt 5.5 years ago, but you just made a payment last month, then it's 6 years from when you made the last payment. Okay, now, and what that means is that the creditor legally cannot sue you. And if they did, you'd have a defense of statute of limitations, and they would violate the law if they did that. Does it mean you don't owe the debt? Well, technically, you still owe the debt. Okay, and so because of that, I've talked to clients that have gotten calls from debt collectors for debts they owed 20, 30 years ago. Okay, tell them don't worry about it. And not that long ago, in fact, more than once, I've gotten clients have written me a letter where it was a letter from a debt collector trying to collect a debt, and the last sentence is something to the effect, by the way, we can't sue you, the statute of limitations is run, but we'd like you to pay the debt. Okay. The person contacts us from Georgia, and they say, I've been served civil legal papers from the sheriff's department, from Citibank. I discovered your office on seniorliving.org. We do a lot of videos with senior living. Reaching out to your office for help or advice on the situation living on fixed Social Security income. Easy to answer that question. You don't need to worry about the lawsuit. You can, if you want to enroll with help, you can stop paying all these debts you've got. We'll send them a cease and desist that are going to leave you alone. You're not going to need to go to court. Okay. Okay, I talked to a really nice lady this morning, worried. She got sued by Capital One. And she went and talked to the clerk of the court. And the clerk of the court said, well, you go and talk to them. Sometimes they dismiss the lawsuit. She had a home that was free and clear worth about $100,000. And the home had some issues with it, some foundation issues. Didn't owe any money on it. And she lived in, gosh, I forget what state. Can't remember, but I do remember the exemption for the state was like $35,000 or something like that. So she had some equity over and above the homestead exemption. And so I explained that she had a couple options. She's been sued for $8,000. First off, I said, that's nice that the clerk of court, the clerk in the court, the clerk at the court behind the desk is giving you some advice that she doesn't know anything about. She's trying to be helpful, but she doesn't know what she's talking about. Capital One isn't going to dismiss the lawsuit. Okay. I mean, I told her I'd be glad to send them a letter and let you deal with them, but you're going to find out that I'm right. I mean, who, when you call them, why would they dismiss the lawsuit? You've got a home that's free and clear, it's worth $100,000, and the exemption $35,000. Why would they just dismiss it? Well, if I pay them 10 or 15%, maybe if you had $4,000 in cash, they might. If you owe them $8,000, they might settle for 50%. I doubt it, but they could. But they're not going to settle for 10 or 15% for $1,000 or $1,500. No way. Now, I did talk to her about a possibility of reverse mortgage, but she had tried that earlier and it wasn't possible. There was too many repairs on the home were necessary, a foundation. In fact, we talked about it, and it might cost as much as the house is worth to get it fixed up to the state where it should be. So I told her she got a couple options. One is, I did suggest that she was 73 years old. Okay, a year younger than me. I said her income was pretty minimal, like $1,400 or $1,500 Social Security. That was it. I said, you might want to consider signing up for Section 8. That's subsidized housing. You may not be interested in it now, but there's a waiting list, and you get on the waiting list, maybe in 2 or 3 years, if they call you on the phone and say, hey, we've got this nice apartment available, and you'll be paying $300 for rent, you might say, wow, I am sure glad I listened to Eric and signed up for Section 8 3 years ago. Now I could really use it. And you could sell the property. If they sued you on this lawsuit and had a judgment, you could pay off the judgment from the proceeds of the sale. To qualify for Section 8 is based on your income, not your asset. So it doesn't matter that you got a free and clear home. There might be an exception in a few states, but generally not. There's not a problem. So I told her not to worry. Then she's, well, are they going to take my home because I have this excess equity over and above the exemption of my state? No, it's not their practice to do that. Okay? Then they just don't do it. If they were, there's a way to stop it. They won't do it. Okay? Eric, after being served to go to court and a person doesn't go when living in an unlimited homestead state, they get the judgment in court. What else needs to be done? Well, nothing, unless you got something in the mail where they're asking for some information. You would get it to help. We tell you what you need to do. But no, you don't need to do anything. That's the nice thing about helps. If you're sued, you get some paperwork after the lawsuit's filed or after the judgment. Get a hold of us. We'll tell you what can be done. We'll give you information. Okay? You're going to be fine. I love court clerks, but a lot of times they don't know everything. Some of them think they do, though. After a Chapter 7 discharge, will a trustee or court still monitor your bank account for any number of years? No, that wouldn't be their practice. One rule to remember, though, if you file bankruptcy and someone dies within 6 months after you file bankruptcy and you get an inheritance and the bankruptcy is over with, then the trustee needs to be informed and that inheritance would go into the bankruptcy estate. That law is in effect, or rules into effect in bankruptcy laws to prevent people from filing bankruptcy just before someone dies. Okay, so this person contacts us from Arkansas, and I'll read the notes. It says here, LVNV funding has been harassing me on a debt. They tried suing, and I showed up in court, and the clerk that delivered the summons said there was no court and the case had been dismissed, but refused to give me the documents for dismissal, stating that I would receive a letter of dismissal from the alleged creditor. Well, you'd receive it from the court, not from the creditor. Well, you guess it. I never got the letter of dismissal, and they gave me a new date for debt origination, which has caused my credit report to plummet. Okay, they refused to remove the debt from my credit report. Please help me. I continue to get turned down for credit due to this factor, alleged debt of $4,500 and $600, neither of which I owe. I tried Consumer Protection and Financial Bureau years ago regarding the matter, which went away and back again. They said it's been handled. Help, I'm 72 years old, senior, single, and Social Security. Okay. We generally helps doesn't help people to reestablish their credit. It's not what we do. We represent people to stop debt collectors from harassing them. However, occasionally one of our clients wants to reestablish their credit. So if you've been part of HELPS for at least 90 days, we have a program, 7 Steps to a 720 Credit Score, that we can enroll you in. It's free to help rebuild your credit. And that could help this person solve that problem that they're talking about. Okay? Mrs. H asks, when a senior owes a student loan and they pass away, will the government take part of the paid off home to settle the student loan that was owed? Do the family have to pay the student loan the senior owed? Well, okay, when you pass on, you die, you have an estate, which means assets that you own. So if the home was in your name and your children's home with rights of survivorship, that means when you die, at your death, the the home automatically goes to whoever's name else's name is on the home. Therefore, you don't own a home when you die. There is no estate. Okay. Now, if all you have is a bunch of old furniture, it's not worth anything, or a car that's not worth a lot. Maybe one of the kids' name is on the car with you. When you die, the car goes to the kid. Maybe someone's joint on the bank account and there's not a lot in there. Mass majority of times, Miss H, our clients don't have an estate. Okay. But technically, if you did have an estate, and let's say you had a home that was worth $200,000, that's free and clear, it was just in your name, and you died, and there was a probate, and there was a will, or even if there wasn't a will, there'd have to be a probate. And then under the probate, your debt gets paid before your heirs get anything. So yeah, if you died and you had an estate and there was money in there, like equity from a home that was in your name only, then the kids would sell the home, assuming there was equity in the home. They need to pay off the debt before they'd get anything. So in that case, yeah, the student loan would need to be paid. But if the home was in the parents' name and the children's joint tenants with survivorship rights, then the debt wouldn't need to be paid, because the home automatically goes to the survivor at your death. Got it? The person contacts us from Illinois. I'm in my mid-40s, and about 5 years ago, I became disabled. It was pretty tough because he had been working all his life. And he's at a loss what to do because of the financial burdens now that he has. He's trying to pay the bills, collections, medical, and so on. Yeah. I got to shut off my phone here. I'm sorry. Well, I can get any help to get things under control and ease the burden on everyday life. I need to put that as one of our title. Helps easing the burden on everyday life, the burden of debt, because that's what we do. So if you're under stress because of debt, please call the number down below. I got paralegals and attorneys online ready to talk to you right now. I promise you're going to feel a lot better after we talk to you. I want to lift that burden so you don't need to worry about it. Okay? It's life-changing for me to not be working, only waking up in the morning, just counting the hours until it's time to go to bed. Oh, bless your heart. No, you can find purpose in life. You don't need to worry about that. It's physical and a mental drag. I don't want you to worry about the debt, please. I'm missing part of he had a traumatic brain injury and struggle with memory issues, among other medical issues. I have my disability income, but the bills just keep getting higher and higher, and payments don't seem to go away. Any help would be appreciated. Thank you. Well, that's what we're here for. We're here to help. Helps. I don't know. I'm going to put a note. I'm going to call this guy. If we haven't called him already, as soon as we're done. I don't like him worrying. This guy from Illinois. I'm sure we've already called him. We don't want him to worry. If that's you, if you're a natural born worrywart, then that's why Helps was founded, to help, specifically to help seniors that owe debt, keep them from worrying, especially to help seniors that are constant worrying about this, so they could always have someone to call. I mean, when we represent you, you don't get charged an hourly fee. You pay a small monthly fee. We're your client forever. You're a client forever. So if you ever have a question, you can call. and talk to us, no matter how often, because I don't want you to worry. And we'll tell this guy, I said, you can pick something else to worry about. I don't want you to worry about something else, and I'll try to help with that, whatever you're worried about, but you don't need to worry about this debt that you're talking to me about right now. Okay. Person calls us from Texas, and they say, my husband and I are interested in filing bankruptcy, but can't afford an attorney. Well, we'll call him back. Probably don't need to file bankruptcy. If your income is Social Security, pension, disability, VA benefits, your income's protected, you're going to be okay. Don't need to worry. And we'll explain why. You can listen to more of our videos. You can get on our webpage, look up videos on senior living. I get encouraged sometimes. I'll get on the internet and I'll get on Google or I'll get on DuckDuckGo and type seniors with debt, answers for seniors with debt, and helps pops up an awful lot, especially on videos. We're there. We overwhelm everyone else because we've been doing this for so long, which is kind of nice. So people find out about us and get the help that they need. But still, there's a lot more people need our help than are enrolling in helps. That's for sure. Okay. From this guy from Florida contacts us and they say, I saw your interview on YouTube. We do a lot of them, by the way. Anyway, I was served 2 days ago from Capital One. Obviously, panic set in. A year ago, I held a 660 credit score. Court date is January 14th. He had some medical issue going on. He has to go into a surgeon on the 14th. I'm also fighting. He has a form of cancer that's relapsed. Okay. And a bunch of other medical issues. I'm on Social Security only for $2,400 a month. I own a small condo at the above address and a 2014 car with a lot of miles. I'm 71 years old and I live alone. The news is out and I'm being bombarded with attorney letters talking about garnishments. Sheriff's coming here to take inventory and remove anything they have that's deemed valuable. I'm obviously a wreck. Oh, you don't need to be a wreck. Who tells you they're going to remove stuff? Okay, you live in Florida. Florida has an unlimited homestead exemption. No one's going to touch your condo. No one's going to touch your car. It may have a little bit of equity in it, but not enough that a creditor would ever be interested. They don't go after cars. Don't do it. Now, why are you getting attorney letters? What you're getting is form letters from attorneys who filed bankruptcy. They subscribe to a service that lets them know if someone's been sued, and they'll send bankruptcy letters. They'll send advertisement letters. They might have a stack that tall, maybe 100 or 200 letters, and the attorney's going to sign each one of them. And maybe there's 3 or 4 attorneys doing the same thing in the state or the county or the area where you live. They're bankruptcy. And the letter says, in effect, hey, you've been sued. If you need help, we can get you out of the step by filing bankruptcy. But, your income is $2,400 Social Security. You don't need to file bankruptcy. Probably can't afford to file bankruptcy. Bankruptcy is going to cost probably minimum $2,000 to $3,000 at least. And you don't need to go through that. And then you might have a problem with bankruptcy with maybe too much equity in that car. Whereas if you don't file bankruptcy, no one will ever go after it. So no, bankruptcy, you don't need. And it says, I'm obviously a wreck. No, you don't need to be a wreck. You're going to be fine. You call and kindly advise me and tell me what to do. Yeah, we want you to call helps and talk to us, and we'll go over this with you. if you're sued, we're going to send a letter to the attorney that sued you. We're going to let them know that your income is Social Security, that you can't pay the debt, and that's going to be the end of it. Okay, no one's going to come to your house and take your property. Now, in Florida, you might get a there's a form they send if you get sued, or if they get a judgment. Client fact information sheet. Some idiot clerk in Florida drafted that form because they ask a lot of questions that are inane, have nothing to do with anything, but they scare people. It scares people, and they think, "Oh my gosh, I don't want them calling my kids." We help people fill out that form. I mean, we tell you what you can do. We don't give legal advice. We give legal information. No, you don't need to worry. You're going to be okay. Very sad they use scare tactics. Yeah, they do use scare tactics. They could use scare tactics. Normally, this advertisement letter, they don't use scare tactics. They're usually pretty innocuous. But if they say something in that letter that someone's going to garnish you, or they're going to come take an inventory and remove anything they deem valuable, I would doubt an attorney would say that. Although I do remember, it's been probably 4 or 5 years ago, a client sent me in one of these letters, advertisement letters, and the attorney had gone overboard with telling them what was going to happen to them. It was really bad. It was so bad that I wrote the bar association in that state and sent him a copy of the letter. I said, "Listen, you need to talk to this guy. I don't want him to get in trouble, but he can't be sending letters like this to people. It's wrong." And the bar took it up, and they sent that attorney a letter. I got a copy of it later with the attorney apologizing to the bar, and he says he won't do it anymore. Yeah. So if you have questions on any of this stuff, give us a call. We're here to talk to you, okay? Melinda asked, my husband lost his job in September. He's 65. He has a lot of credit card debt. He's been forced to take early Social Security retirement. What does he need to do about the debt? Just stop paying? He can. If that's his income, Social Security is protected. And if you don't want to have to deal with the creditors, Contact Helps will send him a cease and desist letter. They're going to leave him alone. Now, if he's got a credit card with a small balance or nothing is owed, as long as that's not backed by a credit card with another bank that he's not going to pay, he could keep a credit card or two if he wanted to. What if you just ignore the fact information sheet? Rico asked. Well, then they might do something else. It's too easy to answer that fact information sheet, and that's all they need. They just need something in the file so that if anyone asks anything, they can point to it and say, hey, look, this guy's on Social Security. He's poor. He can't pay this debt. We got this back, this fact information sheet. Person contacts us from California. I'm 74, received a summons from Shasta County Court that I'm being sued for a credit card debt. He gets about $1,300 in Social Security. Barely afford my own support. He lives on subsidized Section 8 housing, HUD housing. I don't know anything about my car and it's paid for. I'm not sure what to do. Should I try to file bankruptcy? I am so upset about this. Listen, if this is you or someone like you, you do not need to be upset. Your Social Security is protected. They're not going to take your car. And you just pay your rent. You're going to be fine. If you don't want to have to deal with the creditors, you can call us. We can enroll you in Helps. You know, the most a person would pay would be $40 for 24 months, $20 for 24 months, free thereafter. It could be $30 for 24 months, $15 for 24 months, free thereafter, or $20 for 24 months, $10 for 24 months, or free thereafter. Depending on your income, we don't turn anyone away, so it's affordable. Okay, and then we represent you ongoing, so you don't have to deal with collectors. So you don't need to be, like he says, I'm so upset about. You don't need to be upset. You're not going to need to go to court. We're going to send a letter to the attorney who sued you. We're going to let them know that your income is Social Security. You can't afford to pay the debt. And that's going to be the end of it. They can get a judgment, but you're judgment proof. They can't collect from you. Okay? Person calls in, they contact says, I am from they're from California. Good morning. My name is, looks like they're 72 years old. I'm solely on monthly Social Security and a pension, and have no other income nor assets. I'm living paycheck to paycheck due to credit card debt. I tried to move to Nevada to be closer to family, but about seeing the place, it caused me health issues, and I had to return to California. I didn't know Nevada was that bad, but maybe it is. I don't know. In so doing, I had to withdraw my whole month's pension to pay for the move back. It meant not being able to pay for credit card minimums. And I have started missing payments this month. I never moved into the Nevada apartment, and now they are charging me for fees I can't afford. Well, don't worry about it. I offered them a payment plan, but they said no. My priorities are my shelter, food, and health-related issues. I'm back to my old address, and will be able to pay the monthly rent here in California. Because of the moves, I have to wait a month to get a doctor. Soon I will be in collection. I need help and wish to be a client. Yeah, we can help you. That's what we're here for. You don't need to worry about the credit card debt. You don't need to worry about the money owed for the apartment that you never took in Nevada. You can enroll in help. So give us those creditors. We're going to send them a cease and desist letter. They're going to leave you alone. And if you're worried or scared or have a question, you're going to pick up the phone and call whenever you need to. Okay? Person contacts us from Florida. I've been through LVNV funding. That's a debt collector. And I only collect Social Security. I suffer from a form of epilepsy. And I'm very scared. I don't know what to do. I contact legal services, much like legal aid, and they will not help me. Well, we're going to help you. Legal aid is wonderful, but they don't do these kind of things that helps us. They don't represent people like we do. But this guy, he says, you don't need to be very scared. If that's you, if you're really scared about this debt and you're on Social Security or pension, please call us and talk to us. We'll go over this. When the enrollment helps, we'll send a letter to these creditors you owe money to. They're going to leave you alone. And you're going to have peace come back to your life. Like Jimmy says, since joining helps, the only stress I have is what to make for dinner. Okay. Yeah. So you can look some of the comments if you're new to this channel. Look at the comments from people that are part of helps that they say that they how it solved their problem. That's what we're here for. Person contacts us from Michigan. So it says, helps has advised me in the past, which I really appreciate. And he says, I sent 6 credit cards to debt settlement, but after a year I decided they were cheating me, so I stopped paying them. If you signed up for debt settlement, if you're listening to me, if you signed up for debt settlement or debt management, and you're on Social Security or a pension, when you signed up for them, did they tell you that your Social Security and your pension was protected and no one could take it? Now, the answer is going to be no, they didn't tell you that. There's a few exceptions, but mostly they don't. What does that tell you? That they're scammers. They didn't give you complete information. They didn't tell you the most important thing you need to know, in fact, that your income is protected. Why didn't they tell you that? If they would have told you that, you wouldn't have enrolled with them, you wouldn't have paid them, and they wouldn't be making money off you. I can get on my high horse talking about these debt settlement, debt management companies, but don't get me started. Okay, so he stopped paying debt settlement. He says they all went to collections. I'm collection proof, according to you, your advice. He says I don't own property and my only income is SSI and a small pension. So out of the 6 overdue credit cards, 1 has chosen to pursue me. They can't collect, but so far they can put a lien on my property. I don't know what property you're talking about. And lately they put a lien on my state income tax return. Well, you live in Michigan. You don't get a refund, but they give you a property tax refund even if you're renting. They can do that. Of course, we're going to put them to bed because they ran out of time for anything new, but they got a hearing scheduled at the last minute, so to renew the judgment, it looks like. I wasn't warned that they could take me to court for tax returns. Michigan is a state where they have a rule and they have a law in place that even if you rent, you can get a refund based for property taxes. Well, you say, I'm not only renting, I'm not buying. Well, the law says they impute that your rent goes to pay property taxes, therefore they give this refund to renters. And I think it's one of the there may be another state that does this. Because of that, probably more people get sued in Michigan than any other state. I'm really sick. The stress has really harmed me. I don't look at the sheriff anymore, thanks to your service. But I'm really worn out and have no clue what will be thrown at me. It's completely done me in. Well, okay. You don't need to file a tax return to get that refund if you don't want to. Now, if it's a small amount if the judgment's a small amount after it's been paid from your tax refund, you would start getting your refund again. You could file a bankruptcy and wipe out the debt, then you get your refund, but then the problem is coming up with the money to file bankruptcy. So this is only an issue that comes up for people in Michigan. Now, if you're married and the debt's in your name, for example, and you're the husband, have your wife file the tax returns, and then she'll get the refund. Okay? Eric, how are you enjoying living in the South during the winter versus up north? People that know me know that I'm temporarily in New Orleans, and I love it here. I think it was 80 degrees on Saturday, but it's like 50 right now. Temperature can fluctuate dramatically in New Orleans. Okay, we're at the end. Time is flowing by. I got more things to talk about, but I'll start with those tomorrow. Got 3 or 4 pages of stuff. Thanks for participating. Please press the like button, subscribe to our channel, and then if you have any questions, be sure and call and talk to us. We'll be glad to answer them. And we're really nice when you call. You'll feel better. Have a great day, and I will see you tomorrow, same time. God bless. Bye.